Hello. Hello. Morning. Division bench last na? Date 1 na? Acha. Dismiss na?
It's last one disposal for the presentation. Goes to the numbers from.
Petition, Worship. Worship, I beg to mention item number 7.
Yes, item number 7.
7, I have already completed the affidavit, so it has been same for waiting. So this matter may be listed on Friday, 10th of this month.
Friday.
Yeah, coming Friday.
Ah.
And similar item number 8. That's
Same.
what- Yes, same.
Also, you will submit your affidavit
Yeah, I have
in
done
both the
for
cases.
waiting. So I can file the affidavit on coming Friday,
Okay.
on 10th of this month.
Then 10th is coming Friday.
Yeah, this week Friday.
CGC?
Additional. Additional advocacy.
Double AG.
Yes.
Has prayed for. Any objection?
No, my lady.
This is item number 8.
Item number 8.
And,
For the petition.
Okay, okay. Do what about the item number 7?
yeah, I have informed
I-
other party.
Okay, with the consent of the other side. Both on Friday.
Fred, yes.
My lady.
Your Worship, again, I have item number 9.
Yes, item number 9.
Yeah, this matter, I have not received an instruction.
Okay.
So this matter may be released after 2 weeks.
Learned double AG, Mr. Your name, please.
MT Imsong. I am so.
I am Chog.
I am so.
Mr. I am Chog has what was the submission? Item number 9.
I'm seeing for time instruction.
Okay, okay.
waiting for instruction.
Okay. Has prayed for time to obtain instructions from the respondents. Consent has been obtained from the other side.
There,
Katidia to Katidia and consent to Katidia. List this matter when you want?
after 3 weeks,
3 weeks. List this matter after 3 weeks.
and I have another matter 21, item number 21.
As CGC?
21.
Oh, as double AG?
Same.
Okay.
Double AG,
Learned double AG, Mr. I am John, with the consent of the other side,
yes,
has prayed for adjournment. When do you want?
after 2 weeks.
What is the reason for adjournment?
Instruction, this is the same.
Same instruction.
I'm sure there's an interim.
Interim order shall remain in force till the next date of listing.
Lordship, I have another last item number 30.
Hmm.
That is also, I have not yet received instruction.
Lordship, this is a challenge to seniority list of graduate teachers, and promotions are being withheld because of this case. So that may this be the last chance, and if they cannot file it, let the matter be heard on merit.
3030.
30, yeah,
30.
3030.
No,
Learned
30.
Learned WAG, Mr. I Imchen has
IMSO.
Imcho has prayed for adjournment. Post of Learned Counsel Miss Jed Jimomi has raised serious objections stating that the petitioners are waiting for their promotion, for their promotion seniority.
Seniority, Lordship.
Okay. For the upgradation as senior, according to the seniority list, full stop. Several adjournments have been procured by the respondents. Full stop. No adjournments are to be allowed. Full stop. Considering the submissions at the bar, a last opportunity is accorded. A last adjournment is allowed. List this matter after how many weeks?
3 weeks.
3 weeks.
Lordship, obliged.
Yes, my lady.
Yes.
I beg to mention item number 34.
34.
For the appellant here, my lord. My lady, my senior Mr. Inti Longjam is indisposed today. So if this matter can come up next week on the 16th of April.
Your name is in the cause list?
Yes, my lady.
Which one?
The second name, Lucino.
Learned Counsel Miss Lucino has prayed for adjournment as the learned senior counsel representing the
The appellant.
appellants is indisposed today. Mr. M.T. Longchen Likidibade. Mr. M.T. Longjam is indisposed today. Full stop. Learned, yes.
I, Jamir, for respondent number 3, 6, and 7.
Learned Counsel Mr. I. Jamir for the respondent number 3, 6, and 7 is present. List this matter. When do you want?
Next week, 16th of April.
16th.
Obliged.
Next, my lady. Actually, I'd like to mention item number 14. Item 14, I'm for the respondents number 8 to 11. Pleadings are completed,
Okay.
but my senior is out of station, so it may kindly let it come up after a week, next week.
No objection.
Learned Counsel Mr. P. Forte, with the consent of the other side,
Yes.
has
yes, my
prayed
lady.
for objection as his senior Mr. who?
Limawapang is out of station.
Limau, he's a government advocate.
No, I'm for the private respondents,
Okay,
8 to
like-
11.
His
Private
senior
respondents 8 to 11.
Counsel Mr. Limau Pang is out of station.
Yes, out of station.
List this matter when do you want?
Next week.
List this matter on the next week. Your presence, you want your presence to be recorded?
May I please, my lord?
Yes, yes.
Lordship, I beg to mention item 33
Hmm,
on behalf of my colleague Kiangami, your lordship.
hmm.
This matter can be listed after 2 weeks, your lordship.
Item number 33, I think adjournment has been taken already.
Item number 30.
No, 34.
34.
Oh, that was 34?
Yes.
Okay, okay. I marked 33. Learned senior government advocate, Mr. A. Angami, hope it's correct today, N. Angami. Mr. N. Angami has prayed for adjournment with the consent of the other side.
Yes, your lordship.
I'll list this matter.
After 2 weeks, my lord.
After 2
if-
weeks.
if-
If-
Lordship, I also beg to mention item 31.
Mm,
Lordship, on behalf of Kiangami again, your lordship.
mm.
If I've been informed that he is yet to receive instruction in this matter.
Okay.
So if 3 weeks can kindly be granted, my lord.
Okay, learned government advocate Mr. N. Angami on behalf of his senior, on behalf of the leading counsel.
Yes, your lord.
Leading
On
coun-
consult, consult.
private
No, your lordship.
government?
Government advocate.
Okay. On behalf of learned government advocate Mr. K.
K. Angami.
Senior government advocate.
Yes.
Senior government advocate Mr. K. Angami, comma, with the consent of the other side, has prayed for adjournment. Consent?
Yes, your lordship.
You have taken consent?
No, your lordship, I have not.
Consent to
taken any-
Katidia, consent to Katidia. Has prayed for adjournment, list this matter when do you want?
After 3 weeks, my lord.
After 3 weeks, okay.
I'm deeply obliged. my lord.
Please, Your Lordship, I beg to mention item number 27. Kindly allow me 3 weeks' time to file affidavit in reply to the opposition filed by the state government.
Okay. Learned counsel Miss
K. Lily Su.
K. Lily Su. On behalf, oh yes, learned counsel Miss K. Lily Su, comma, with the consent of the other side has prayed for time to file affidavit in reply against the affidavit in opposition. List this matter when you want?
After 3 weeks.
After
Lordship.
3 weeks.
Yes,
Okay?
Lordship. Much obliged.
Lordship, I'd like to mention item 6, Lordship.
Hmm.
If 3 weeks' time you granted to me, Lordship. 6.
PP, or government advocate.
Government advocate.
Learned government advocate Miss, your name?
S. Chang.
S. Chang,
Lordship.
with the consent of the other side.
Yes, Lordship.
Consent?
Yes, Lordship.
With the consent of the other side has prayed for adjournment. List this matter when do you want?
After 3 weeks, Lordship.
After 3 weeks.
Lordship, I have similar prayer for item 11, Lordship.
Same order?
Same order, Lordship.
Same order, item 11.
For item 13 as well, Lordship. On behalf
Same
of my
order.
colleague, Lordship.
Same order?
Yes, Lordship.
Same order, item 30.
Item 15 as well, Lordship.
Same order.
On behalf of my colleague.
Okay.
Item 17, Lordship.
But just a moment, item 15 is CGC.
CGSC.
Ah,
Yes, Lordship.
okay. Learned counsel Miss S. Chang. Learned government advocate Miss
Lordship.
S. Chang. On behalf of learned CGC, Mr.
On behalf of
Ah.
state respondents, Lordship.
Okay. On behalf, okay. Agor nisnake likhi diwa, same order. Any objection from your side? From this side? You have taken consent?
No, Lordship.
Consent to Katidia. You have any objection?
No.
Your presence, you want to be recorded? Your presence.
Lordship.
Okay. With the consent of the other side has paid for adjournment, learned counsel Mr. Moaz Amir is present for the petitioner. List this matter. Kiman কৈছিলে আগতে? 3 weeks?
3 weeks, Lordship.
Obliged.
Lordship, I have similar prayer for item 17.
17.
Lordship.
Same order? Same order?
Yes, Lordship.
Same order লিখি দিবা, 17.
Item 18 as well, Lordship.
18, same order. You have taken consent?
No, Lordship.
17, you have taken consent or not?
Yes, Lordship. He was
17
here.
to consent, this 18 also consent from the other side. Any objection? Same order.
Lordship, I have similar prayer for item 19 as well, Lordship.
You have taken consent? Any objection? Same order. You want your presence to be recorded? Your name? What is your name?
Yuka Kokla.
Okay. Learned counsel Miss Yuka Kokla is present on behalf of the, is present for the petitioners.
Lordship, item 20.
Same order, item 20. You
Item-
want your presence to be recorded? Your name?
Sekmo. Item 22 as well.
In item 20, you know?
Yes, Lordship.
SECMO. Learned counsel Miss
Sekmo.
SECMO
Yes.
on behalf of
Supungwati.
Supongwati Waling, representing the petitioner. Petitioner, no?
Yes, Lordship.
Okay.
Lordship, similar prayer for item 22 as well.
22 or 3?
22, 23. 22 and 23.
22 and 23.
Yes.
And you are for 22 and 23?
Yes, Your Lordship.
Same order, huh? 22, 23. Sekmo Chang, no?
Yes, Your Lordship.
Etu to Harry represent on behalf of his Sukumaling Nalagate, Namdo Asay 22 or 23. Okay.
Lordship, I have similar prayer for item 25 and 26, Lordship.
Okay. But who is on the other side? Somebody else. Same order, 25, 26. What is your name?
Mika Echayan.
Me?
Mika Echayan.
Oh, Mika H.I. Mika M.I.K. Mika H.I.
Lordship, item.
Both the cases.
Yes, both the cases, Lordship.
You're present in both the cases. Okay.
Lordship, item 35.
35.
35. Hearing item.
Item 35. Same order.
Is if this matter can be listed after 3 weeks, Lordship.
After 3 weeks?
Yes, Lordship.
এখানে নামটো টসি টেমজিং
Yes, Lordship.
পঙ্গেনার
Yes.
এখানে নামটো লিখি দিবা হা you want your presence to be recorded
Respondent number 6, Lordship.
name what is your name
Imtila.
Imtila Pongen respondent number 6
Yes, Your Lordship. Your Lordship, I beg to mention item number 24.
24
Your Lordship, we are yet to file our affidavit reply.
okay
So 3 weeks may be granted.
learned counsel for the petitioner Miss T Sekmo Chang has paid for time to file affidavit in reply. It will
Yes,
be no?
Lordship.
Affidavit in reply. Learned senior government advocate Mr. N. Angami is present. Please this matter when you want 2 weeks. 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Obliged.
May I please, Your Lordship, I beg to mention item 28 on behalf of Lakney Home. Lordship will file the IA for impeachment of necessary parties. However, due to some error, it could not be filed yet. So I pray for some time to rectify.
What is your name?
Rebecca,
Learned counsel Miss Rebecca on behalf of learned counsel Miss Lakne Home. Miss no? Mr. Lakne Home, representing the petitioner, has prayed for adjournment. Learned government advocate Miss S. Changa is present. You have any objection?
No, Lordship.
List this matter after 2 weeks. 3 weeks.
3 weeks.
3.
For motion, item number 1.
Please,
Yes.
Leadership. Leadership, item 1 and 2 are connected.
1 and 2 are connected?
Yes, yes,
Okay.
yes. So, very peculiar case, Your Leadership. The trial was conducted by one judge. The judgment was delivered by another judge, and the sentence pronounced by a third judge. And that's how we landed up here, Your Leadership.
Okay.
So the allegation in this case is that a sum of rupees 26 lakhs meant for refilling an ATM booth in the Naharbari Junction, Dimapur, was robbed. That is the allegation, and that is
Item 2 also. Yes.
yes, that is the allegation. That is the FIR which was filed. So the FIR simply states, if I can take your leadership to the FIR, page 28.
Are you asking for bail
Yes,
in IA?
yes, your leadership.
Yes, you want
Notice go.
Your leadership, an application under 433 was filed. The little trial court, since it is sentenced of 3 years, allowed us bail. We were already on bail. We were continuing on bail and allowed us to approach the Zombie Court by filing 430, an application under 431. So 431 is that application. We are already on bail. Your Leadership.
already on bail.
Yes.
Okay, let us extend the bail.
TCR be called.
Yes.
TCR.
We'll call it
TCR,
TCR.
yes.
Yeah. Both the cases.
What a case.
Punishment.
Same case, your leadership.
Okay, same case. Okay, punishment, different accused.
Definitely.
Give me that BNS. BN-SS. I will take up the IA then, no?
Yes, your leadership.
Only the IAs. In both the cases?
Yes, your leadership.
Your Ladyship may kindly grant me a short time to go through the brief because just recently I've received the brief, so.
After some time then?
After a week, Your Ladyship.
But Your Ladyship,
3 years,
yes,
it's 3 years punishment.
Yes, Your Ladyship.
and we are already on bail. Your Ladyship.
They are already on bail.
After 2,
After 2,
yes.
okay.
No, after 2 today.
Means he says,
Today.
yes.
Okay.
It
After
is-
2.
I want to go through the brief.
Sure, after 2 years.
Very, very good.
After 2 then, huh? Both the cases 1 and 2.
For motion, item number 3.
Members, Your Lordship, Your Lordship, the present writ petition is filed for non-considerations of the petitioner application that is dated 6th February 2025, seeking for compensation for the damages that was caused to the petitioner land and plantations due to the landslide and construction activities during the development of the National Highway NH29 4-lane. Located at Lisa A. Colony, Sechu, Zubza, Kohima, by the respondent company, namely the NHIDCL. Lordship, the case of the petitioner is that during the construction and excavation process, the petitioner lane was also acquired. However, at that time, at till date, no compensation has been granted to the petitioner. However, the other affected landowners who were also included in that, they were given compensation except by petitioner, Your Honor. Your Honor,
We'll issue notice. You have a case, we'll issue notice.
okay. Much pleasure.
Learned Counsel, Miss
Longzbini.
Longsu Beni. LONGTSU. ইয়াতে আছে হা গোটেই নামটো লিখি দিবা is present for the petitioners. Learned Government Advocate Miss S. Chang learned is present for the respondent state. Petitioners to take steps to issue notice to the other respondents. Full stop. You have received notice? No. Okay. Petitioner to take steps to issue notice to the respondents. Returnable within 4 weeks? 2 weeks? 4 weeks. So you can bring instructions also if there is any progress of consideration of his compensation. If you make, you can bring instructions. 2 weeks. Did they say 2 weeks or 4 weeks?
4 weeks.
4 weeks. Right. List up for 4 weeks.
For motion, item number 4.
Please, Lord.
Yes.
So this matter relates to the promotion to the post of secretary in the Nagaland Legislative Assembly. It is the powerhouse headquarters. The private respondent number 4 has been promoted without following the due process of law and superseding the lead petitioner. Caveat has been filed on behalf of all the respondents. So, and that too by 2 prominent lawyers. And I'm praying for suspension of the interim order, the MDN order. Therefore, I will be compelled to take little more time to take into the facts of the case because it will be important to understand the background and the facts of the case. As far as possible, I'll try to be in brief. Page 22, Lordship. This is the appointment order of the petitioner. Both the lead petitioner as well as the
What suspension are you bringing for? Whose suspension? What suspension order? The
promotion order. Promotion order.
To suspend the promotion order.
Yes, because it is like this. The petitioner as well as private respondent number 4, they were all appointed on the basis of an
Let us first issue notice to the respondent number 4.
Issuing notice is not a problem, Lordship, but kindly
You are
bear with
for
me
government.
for a short
With due
time.
respect, may I interrupt
Ah,
for 1
yes.
minute?
Ah.
Lordship, I was given,
Without proper hearing, we cannot
I was given
suspend.
officiating charge in
Ah.
the year 2022. Thereafter, an interim order was passed staying the officiating charge
Oh,
of
you
my
are
client.
the respondent number 4.
I am the respondent number 4. An officiating charge was given to me in the year 2022. Thereafter, the petitioner filed a writ petition challenging the grant of officiating promotion to me as secretary. That order was suspended by this honorable court. Then I filed an IA. Then the interim order was vacated. Then against the vacation of the interim order, the petitioner filed a writ appeal. Then thereafter, my lord, the writ that, and thereafter, my lord, before the writ appellate court, the vacation of the interim order was upheld. Thereafter, the writ petition has been withdrawn. Since 2022, I'm holding the post on officiating charge. Then thereafter, I was promoted on 9th of March. So what is
Not
the hurry?
promoted,
So my respect,
regularized.
so my respect was sufficient. Due respect. Is that instead of taking a long time on pushing of interim, why not the short notice is issued and within 2 weeks' time we file our affidavit in opposition, we dispose of the case once for all on
Yes,
merit.
yes. Because you see
Instead of-
a suspension, one promotee suspension.
And I have already assumed charge.
Hmm. So let us issue notice and then we will hear it
Lordship,
finally.
going by the summation of my learned
2
friend,
weeks' time, without going on to the merit.
2 weeks time.
2 weeks, we'll file
2 weeks'
affidavit
time,
in 2 weeks'
then-
time.
let the summation of my learned friend be
Recorded.
recorded. And I do not know what the respondent authority says. If it is 2 weeks, I have no objection to that. Let the matter be heard finally. And they should file the affidavit within a period of 1 week so that I get time to file reply.
Okay.
And it may be disposed of at the admission stage by way of an admission hearing also.
Even at the motion stage also.
Yes,
Because you
yes,
see
even at the
already
motion
a
stage.
promoted person. He's already a promoted person. Can be disposed of the
My
motion
lady,
stage
this is
also.
the 7th round of litigation.
Hmm.
This is the 7th round of litigation, so. it will be-
Lordship, the implication of the interim order, if the present promotion order is suspended, there will be no change. Because as submitted by my learned friend, she was holding the officiating charge of secretary since 5/7/2022.
Seniority may be affected, no, if promotion is suspended.
My seniority has been affected.
Yes.
You are not affected at
Then
all,
we are going to hear you.
Lordship. So let it
So
be
you
heard
are
within 2
superseded.
weeks.
I know you have a case. She has superseded you. But when you come out triumphant, then you'll get all the benefits.
Yes.
Lordship,
Learned,
may I pray that Lordship may also make a mention that although I have pressed for an interim order,
yes.
but then since it is a matter to be disposed of within a period of 2 weeks, so interim is not considered today.
Can be recorded. Can be recorded. Learned Counsel, Senior Advocate Mr. C.T. Jamir, assisted by
I am Chen.
Learned Counsel Mr. I. Imchen, representing the petitioner, is present. Full stop. It is submitted that the respondent number 4 has superseded the petitioner, who was the deserving candidate to be promoted as secretary, no?
Yes.
Who is the promotion order you have impugned?
Promotion order is at page 148. That is the type copy. 148. That is the impugned order where the private respondent number 4 has been promoted.
As secretary to the Nagaland Legislative Assembly Secretariat, full stop. The it is also prayed on behalf of the petitioner that this impugned order number AS/ES/T/15/2008 within bracket VOL-1 bracket close to me bhalke চাই ল'ব দেই page 148 comma more within bracket আকৌ within bracket লিখা annexure R bracket close page 148 আছে হা dated Kohima the 25th March 2006 maybe stayed maybe stayed full stop learned counsel Mr.
Takamasa.
Huh?
Takamasa.
Takamasa, senior advocate.
Yes.
Learned senior advocate Mr. Takamasa for respondent number 4 has raised serious objection stating that the respondent number 4 has been highly prejudiced due to the slew of litigations brought up against lady, no?
Yes.
Respondent number.
Yes. What ladies?
Okay.
It's a fight between two ladies.
It's a quick fight.
And men are fighting. 3 men are fighting for 2 ladies.
Yes. So it is a serious matter, must be disposed of soon.
Yes.
Miss Kill to me. Oh, litigations brought up against her by the petitioner. By the petitioner, no?
Yes.
It is also submitted that she has been, you have stated, Sabina, she has been serving as in charge.
Yes.
Officiating,
Oh,
temporary officiating charge.
as
Since-
temporary of, she has been serving as temporary officiating.
Charge.
Since.
Serving as, no, she was in charge as the, no.
Secretary.
Secretary in charge.
Oh,
Secretary
in charge secretary. She was serving as in charge secretary since you have given a date also.
5/7/2022.
Okay,
5/7/2022.
2022.
And she had already assumed charge after
And-
being promoted.
And after being promoted, she has already assumed charge. Full stop. If the matter is stayed, or if the order of promotion is stayed, the respondent number 4 will be highly prejudiced. Full stop. As the learned senior advocate has also prayed for time to file affidavit so that the matter can be disposed of without passing any interim order, disposed of expeditiously without passing any interim order. Learned counsel Mr.
Yeah, Lordship, I'm appearing for respondent number 1, 2, and 3.
TB Jamir, no?
Lordship.
Learned senior advocate.
No, Your Lordship.
Learned counsel Mr. TB Jamir is present for respondent number 1,
2 and 3.
2 and 3.
Yeah, I have similar.
And he
prayer.
has considered to the submissions by the learned senior advocate Mr. T. Masa. Okay. Considering the submissions at the bar, the respondents are, the respondents may file their objection within 2 weeks. And this
Affidavit in opposition, Lordship.
file their affidavit in opposition within 2 weeks, and this matter may also be taken up for final hearing, considering the
Urgency involved in the matter.
urgency involved in the matter. Yes.
And on that day, the record may be produced, Lordship, by the respondent number 1, 2, and 3. Lordship.
Okay, the records may also be produced by the respondent number 1, 2,
And 3.
and 3.
And the next.
1, 2, and 3?
But Respondent number 1. Your
Respondent
report-
number 1,
Thank
by the
you.
respondent number 1. Okay. List this matter, do you want a date?
Proceed as patient. After 2 weeks.
21.
Huh?
21.
21?
Proceed on that.
21?
Well,
21.
let the matter be listed for admission hearing.
Okay. We can list it. The matter can be listed for hearing on admission. The matter be listed for hearing on admission. Can be not be listed.
For motion, item number 5.
I don't know, somebody has taken an, I think any order has been passed during motion. There's a tick mark here. No, no. Item number 5, no?
Item 5, yes.
Okay. I don't know, there's a tick mark here, so I thought something must have mentioned it.
So, Your Ladyship,
Yes.
civil suit was filed by the respondent, and in the civil suit, there are 3 properties which are the suit properties. And these 3 suit properties were purchased by the petitioner's father much before his marriage to the respondent. Now, in the civil suit, the claim is that these suit properties were purchased after their marriage, and so she's claiming those properties. That is the case in relation. But the documents on record, they very clearly establish that all these properties were purchased prior to her marriage to the petitioner's father. And in a very
So this judgment was passed by the
trial court first, Your Ladyship, in the
then
injunction petition.
appellate court.
Yes. And then I filed an appeal against injunction petition. The orders passed an injunction petition. They appealed, my appeal was dismissed, upholding the order of the trial court. That is why I'm now before the Supreme Court, Your Ladyship.
Yes. Can issue notice.
Very, very, Your Ladyship. And in the meantime, Your Ladyship, the respondent, of her own volition, she left the suit properties. And her marital home is also in the suit property. My individual home, my home, the petitioner's home is also in the suit property. But by the temporary injunction order, I have been restrained from entering into all suit properties, including my home.
So where is staying now?
I'm still staying there, Your Ladyship. And in spite of the fact that she had an interim order, an interim injunction in her favor when the order was passed, she did not come back to the suit property. Till today, she's not back in the suit.
So you stay peacefully. We'll issue notice.
Very, very, Your Ladyship. But as an interim stay also, Your Ladyship, so that there are no complications.
Interim stay.
Yes, Your Ladyship.
Then we'll have to hear you out.
That can be done, Your Ladyship. That can be done.
Then after hearing you out, if I'm not satisfied, then
I'm sure Your Ladyship will be satisfied. I'm sure Your Ladyship will be satisfied. Can I take Your Ladyship to the plaint? There's a few facts I'd like to show you, Ladyship.
not the plaint. Judgment and the dismissal order.
The judgment of the trial court, page 78,
Not the trial court. Appellate court.
appellate court, page 200.
It will, I think, it will, the
Your-
submission will be compact then.
Yes, but Your Ladyship will be satisfied even with that. Page 200.
Because trial court, appellate court judgment will be
Yes, Your Ladyship.
dealing with the trial court
Yes,
judgment,
it does.
and the dismissal order will be dealing with everything.
Yes, yes.
So we can compress the
In the facts of this case, Your Ladyship, that's why I come under 227.
yeah.
It may not. That is why. It may not.
No, but going to the petition and everything, it will complicate the matter. Going to the
no.
plaint and everything.
Based on the pleadings of the respondent himself, herself, Your Ladyship will actually come to see that the suit is false, frivolous, vexatious. Actually, everything is there on record.
So who has filed the plaint?
The respondent.
Okay, then let's go to the plaint.
Yes. Page 39. Your
Suit
Ladyship.
was brought up initially by the respondent.
Yes, Your Ladyship.
The wife,
Yes, yes,
estranged wife.
yes. No, the father died.
Ah,
The petitioner's father died.
okay.
And these problems cropped up after his passing. She started claiming all the properties. That is why, Your Ladyship.
No, who has brought up the
The respondent has filed a suit.
Respondent,
respondent
he is the estranged wife.
No,
She is the husband.
died. Yes.
Husband.
So the respondent is the petitioner's stepmother,
Stepmother, okay.
second wife of the petitioner's father. Second wife.
Stepmother of the petitioner.
Yes.
And second wife of the
Petitioner's
deceased.
father. Yes.
Second wife of the
Father.
deceased. No. Let's not stay the matter.
No, Your Ladyship can come.
No. Let us issue notice.
Your
You see?
Ladyship, there is just one point I would like to draw to your Ladyship's attention. Just if you can go to the plane, just some paragraphs I'd like to show to
I
you.
can go, but you see, she's a woman.
But she's not on the suit property. Your Ladyship.
Why should I debar any woman from being a second wife? That is also recognized by.
Then, no, that's all right, Your Ladyship. I have no arguments against that. All those issues are yet to be decided. All these issues. But
Being the second wife, she has, why should I debar her from
No.
entering?
I'm not saying that she should be debarred, Your Ladyship, but not at this stage. What I am saying is this, Your Ladyship. Even though she had an interim injunction in the favor, she did not return to the suit property. And the interim order debars me from entering into my own property.
But you are in the property.
I'm in that property. So that protection should be given to me, Your Ladyship. That is what I'm trying to say. In fact, when the appeal was filed, there was an interim order which protected me, saying that insofar as my property, my residence is concerned, that is exempted from the interim order, from the interim injunction. But in disposing of the appeal, that protection was not given to me. Can I show the interim order then in the first appeal?
Yes.
In the,
No, it's not required. Actually, not required. Now I'm following your submission.
yes, Your Ladyship.
Okay.
If that protection can be given to me, that I should not, that the interim order.
Yeah, we can go through the
Yes.
plaint. We can go through the plaint.
We can go to the
Yes,
Your
yes.
Ladyship. Page 39. Page 39. The plaint begins at page 39. And the first page in the cost title, Your
You see,
Ladyship,
I have a problem here. There are double numberings of the pages. 32, okay.
page 39 now. Page 39, Your Ladyship. 39.
37.
Double numberings, Your Ladyship?
Yes.
I'm sorry, Your Ladyship. I'll make this correction. I'm sorry, Your Ladyship.
Is it civil miscase number 88 of 2024?
Page 39 is title suit 2 of 24.
Title suit 2 of 24.
Page 39. 39.
Here it's okay. Up to this page, it's okay. No double numbering. Okay then. Title suit 2 of 2024. I got it.
39.
Mm.
And the three properties are mentioned here in the cost title. Your Ladyship, serial number 1 at the bottom of the page. Registration number 1409.
Mm.
Then number 2, 6605. Number 3, 1717. These are the three properties which the respondent is claiming in a title suit. Then
She's your stepmother?
my step.
Plaintiff? Okay.
Yes, someone. And I'm implemented here as the sole defendant.
Mm.
Ladyship, you see that in the area
Yes,
of
yes,
in the
yes.
first page?
Yes.
Yes. Now, the paragraphs 1, 2, these are recital of facts. Then 3, 4, 5, 6, all this, Your Ladyship, can go all to all that. And Your Ladyship can come to paragraph 9 at page 45.
Yes.
Paragraph 9, page 45. She says a lot of things against me in the plaint, but the circumstances, of course, with a pinch of salt, if I may add, Your Ladyship, how she left the suit property. At paragraph 9, page 45. Her own statement.
Okay.
Paragraph 9. May I read, Your Ladyship? The plaintiff, legitimate sister, her own sister, on coming to know that her sister is being mentally harassed and threatened by the defendant, his son and family members, went to the matrimonial home of the plaintiff, and on coming to know that the plaintiff's life is being threatened, told his sister plaintiff to pack her belongings so that the plaintiff can stay with them for a few days and come back to a matrimonial home. When the plaintiff's sister reached the house, there were around 4 to 5 members of the defendant who was already present there. Excuse me. The defendant and his relatives were not willing to allow the sister to take the plaintiff, since the plaintiff still had some money with her, but the plaintiff's sister fought against the defendant and his family members that they will take their sister with them. In spite of all these, the defendant and his family members were not allowing them to leave the house, but since the plaintiff's sister saw the suffering which the defendant and his family members were inflicting on the plaintiff, they agitated against them. The defendant and his family members were on seeing that they cannot stop the plaintiff's sister from taking the plaintiff, told them that until and unless they signed on the paper, they would not allow the petitioner's sister to take the plaintiff. The defendant and his family members then drafted a note and forced the plaintiff's sister to sign on the note, failing which they cannot take the plaintiff with them. The defendant and his family members even forced the plaintiff to sign on it, but she refused. However, the plaintiff's sisters signed on the date on the note. It may be stated here that the plaintiff's sister was forced and compelled to sign on the note by the defendant and his family members as they refused to let the plaintiff go with his sister. The note is dated 23/10/2023. And in fact, Your Ladyship, this is a note which they themselves signed. The plaintiff's two sisters and one of her sister's husband. All the facts are not mentioned. And this is 23/10/2023. So from 23/10/2023, she left her marital home and she has not returned. Now, what does she want in this suit, Your Ladyship? And Your Ladyship can kindly flip a few more pages and come to page 50. Page 50.
Okay.
Page 51. Page 51, Your Ladyship. Page 51. We
Page
can come to the
51.
paragraph which starts at paragraph 18.
Variety.
Yes.
Yes.
That the plaintiff submits that out of the 3 plots of land, the plaintiff had requested the defendant and his family members to give her the plot of land at Chungirima village, registered before the Chungirima village council bearing registration number 1409 and bounded by.
Okay.
So this is out of the 3 plots, this is what she wants. Then, however, since the defendant and his family members had refused and denied the rights of the petitioner, the plaintiff approaches this honorable court seeking for declaration of rights and title of all the 3 plots of land, and the honorable court may, on further perusal of the case, may be pleased to grant all the plot of land as described by the plaintiff.
Okay.
She wants this plot, and this is not even the plot where the marital home is. This is a different plot, Your Ladyship. And next paragraph, that the plaintiff, under the circumstances stated herein above, therefore prays that there are 3 plots of land standing in the name of her late husband. However, since the defendant is reluctant to come to terms, the plaintiff prays that the court may be pleased to grant the plot of land as described in schedule number 1 of the cause titled prayer, or may be pleased to grant all to the plaintiff. But she wants 1. And 1 is in the title suit, in the cause title, the page, Your Lordship, in the first page of the title suit, at page 39, it is the plot which is covered by registration number 1409 at page 39.
Okay.
And
This is the one she's asking
this
for.
is
no?
the one she's asking for. And the plot on which the marital home as well as the respondent's home is the second plot, registration number 6605. She doesn't even want to return to the marital home. And the basis of her claim, Your Ladyship, is that she says all these 3 plots were purchased by her and her late husband after their marriage. Not true. The documents clearly show that all these documents were purchased much before. And Your Ladyship can come to that. These documents, which are beginning from page 17.
Page 17.
Page 17. So these are documents issued by the village council, Your Ladyship. These are not the usual patas or jamabandis that we know, which are issued in the surveyed areas. And Your Ladyship will see page 17, annexure 1. It is a folded paper, Your Ladyship, yes.
Yes, page 17 and next
Yeah.
one. Yes.
This is serial number 1717. The date of registration 21/5/2026. Now these are 25. So these are renewed from time to time. So this is the current date. But in column number 3, if purchased when, whom, and when. Your Ladyship will see this was allotted in 1972. They were married in the year.
Column number 3.
Yes.
Yes, yes. Yes, 1972, yes.
Yes, 1972. Then the next block, the type copy is in the next.
It's okay, one plot is enough.
Yeah.
This is just first plot.
Yes, no, this is not a first plot is a serial number 19. 19, page number 19,
Okay. Which he is asking for.
which she's asking for.
She prefers.
Yes.
Which she prefers.
Yes.
Okay.
At page 19, and this is serial number 1409. Is the Rishi got it at page 19?
Okay. This was adopted in the year 1989.
Yes.
And when did she get married to her?
They got married on 8/1/2021. 8/1/2021.
Yes, yes, it is in the petty plaint, no?
Yes, Your Lordship. That's the basis of a claim.
Okay, then where is the dismissal order? This is enough.
Yes.
This plaint is enough, I think.
Yes.
Where is the dismissal order?
Dismissal order is at page 100, page 200, Your Lordship. In the first appeal, Your Lordship.
Now you are against this order.
Yes, plus even the trial court's order, Your Lordship.
Okay.
Both, Your Lordship.
No, for stay, all the orders may not be considered. Let's see page 201.
Page 200, Your Lordship.
200, okay.
Yes. Annex 11, page 200.
Mm.
It's a short order. May I read it, Your Lordship?
Yes, yes, please read.
201, beginning from page 201. The instant appeal is filed under Order 43, Rule 1R of the Code of Civil Procedure, assailing the impugn order dated 22/8/24, etc., etc. Then, paragraph 3, the facts in brief, germane, are as follows. The appellant respondent is the adopted son of the deceased, late M. Senkoma Kikon, who expired on 28/8/23. And the respondent plaintiff is the legitimate wife of the deceased, who got married to the deceased on 8/1/21. After the demise of the first wife of the deceased, late M. Kikon. And after the demise of late M. Kikon, the appellant respondent started threatening the respondent plaintiff and has also taken away all the properties, documents from the respondent plaintiff. It was alleged that the respondent plaintiff has left the matrimonial home on her own free will, whereas the case of the respondent plaintiff is that, on account of threat, harassment, and humiliation, she was compelled to leave her matrimonial home. The learned counsel for the appellant respondent submitted that the suit is based on, for the fact that the respondent is no more residing in the address mentioned in the plaint. The learned counsel submitted that the marital home of the respondent plaintiff and the residence of the appellant respondent are on the plot covered by the document bearing registration number 6605. That is the plot which I referred to earlier, leadership, and the fact of which was suppressed. It is further submitted the respondent's claims right, title, and interest on the ground that the suit properties were jointly purchased by her and her late husband after their marriage on 8/1/2021, which is contrary to the land registration records. It is also submitted that as per the Lotha customs and practices, the appellant is the sole heir to the estate of his late father and he inherits his late father's immovable property as well as movable assets. This would mean that the respondent has no right whatsoever to claim the money standing in the accounts of the appellant's late father and or immovable properties purchased by his late father. In support of her argument, learned counsel placed reliance upon the following judgments. Then 203, the learned counsel for the respondent plaintiff submitted that while granting the impugn order, the lower court below has taken into consideration all the three golden principles for granting temporary injunction. It is further submitted that the appellant claimed himself to the adoptive son of the deceased. However, till the appellant has no material to support his claim. On the other hand, the respondent plaintiff is the legitimate wife of the deceased, and therefore she has every right, title, and interest over the properties left behind by her late husband. And the appellant husband is using all means to deprive the respondent plaintiff of the properties left behind by her late husband. The respondent plaintiff has left the matrimonial home, being compelled by the constant threat by the appellant plaintiff, and for which the respondent plaintiff has lodged an FIR before the Chumilima PS as well as Women PS Dimapur. The learned counsel also placed reliance upon. Then 6, I have considered the submissions advanced by the learned counsels and have also perused the materials available on records. The facts revealed from the record shows that the instant case arose between the appellant, respondent, who is an adoptive son of late M. Kikon, and the respondent plaintiff, who is a legitimate wife of the M. Kikon. And the present appellant claims absolute right, title, and over the properties of late M. Kikon. And on the other hand, on account of constant harassment and threats, the respondent was allegedly compelled to leave her matrimonial home. It may be observed herein that the respondent plaintiff being admitted to be the legitimate wife of deceased L. late M. Kikon, she cannot be deprived of her rights and interest in properties of her late husband. That I have also further perused the impugn order passed by the learned Civil Judge Senior Division, and it is seen that the learned court below has passed the impugn order dated 22/8/24, granting temporary injunction in favor of the respondents after considering all the materials placed on record based upon specific findings on all the three golden principles that governs grant of temporary injunction under Order 39 of the CPC. Further, the impugned order or perversely aware the court has ignored the settled principles of regulating grant or refusal of interlocutory applications. And this is not so in the instant case, and therefore such order needs no interference by this court in the exercise of the appellate jurisdiction. In view of the foregoing aforesaid analysis and reasons, the instant appeal sailing upon the impugned order dated 22/8/24 stands dismissed.
So what was the prayer in the plaint?
Page 39, and the prayer now, Your Lordship, is at beginning from page 51. In the premises stated above, considering the facts and circumstances of the case, the plaintiffs therefore prays for the following reliefs: a decree declaring the title of the suit land covered by the first plot, the plot which she is claiming, then all the three plots. After that, all the three plots.
This is because the petitioner is the adoptive son.
Your Ladyship, the plaintiffs, the petitioner's father had three brothers. The elder brother, M. Kikon, he did not have any issues. So he adopted his younger brother's son when he was 2 years old. And that is permissible in terms of Naga customary.
Anything mentioned in the plaint about his adoption?
No.
From his nothing?
No, nothing is mentioned. In the plaint, nothing is mentioned. In my written statement, I have filed a written statement as well as a counterclaim.
There you have mentioned?
Yes, everything I have mentioned.
Where is it mentioned in your written statement? Have you annexed it?
Written statement? Page 109. Paragraph 6, page 1111, the brief facts of the case. In the first 6A itself, I have mentioned the litigation.
Page 111.
111. 6A, 6B, and 6C. 6A, 6B, 6C.
Okay. See, what's your prayer in this petition?
To caution set aside both the orders as well as dismissal of the application for temporary injunction.
So no interim prayer?
The interim prayer is there, Your Ladyship.
Hmm?
In page 14. Page 14. At the bottom of the page. Page 14 of the petition.
See, without staying these two orders, can I pass an order that he may not be restrained from staying in his present?
No, that's also fine.
That will be better. Staying in his present residence where he's staying.
Yes, Your Ladyship.
Okay. Item number 5, no?
Yes, Your Ladyship.
Okay. Hard learned counsel, senior advocate?
No, Your Ladyship.
Hard learned counsel, Mr. A. Jumomi, for the petitioner. This is land dispute, no? We can name them, no?
Yes.
Petitioner Sri T. NZDNT nice style of petitioner naam to, who is aggrieved by the order dated 200, no?
Yes, Your Ladyship. 3126.
30/01/2026 in civil. In IA.
No, it's civil appeal. It should actually have been first appeal, Your Ladyship, but civil appeal 2 of 2024.
In civil appeal number 2 of 2024, title suit. I think it is title suit.
Arising out of IA.
IA. And title suit is also 2 of 2024. I don't think so.
Could be, Your Ladyship. We don't have that many filings as such in the.
Okay. Arising out of IA number 88 of 2024, in title suit number 2 of 2024, full stop. The order, full stop, the order is marked as annexure 11 of the of this writ petition, full stop. The a respondent, Srimati Lizano Kikon, alias Lizano Kikon, is the petitioner's stepmother, full stop. She was married to the petitioner's father, M. Kikon, no?
Yes, it is. MP.
M. T. Kikon, M. T. Kikon, K-I-K-O-N, M. T. Kikon, on 8/1/2021, full stop. The petitioner is apprehending that owing to the order passed, order dated 30/1/2026, he may be restrained from entering into his own house.
Yes.
Is apprehending, no?
Yes.
Full stop. The respondent had brought up a title suit against the petitioner, registered as TS number 2 of 2024. With prayer for a decree declaring title over the suit land described in the schedule of the plaint. Full stop. The respondent preferred to the respondent had a preference over the
Plot covered by registration number 1409.
yes, plot of land covered by registration number 1409, situated at Sumuk, CHUMOUKEDIM, Sumuk Demia Village A, and is described in the plaint. Full stop. The respondent has also prayed for title over other suit properties more fully described in the plaint, in the schedule of the plaint, more fully described in the schedule of the plaint. Full stop. It was submitted by the respondent that she, along with her deceased husband, during his lifetime had purchased the suit properties, whereas in fact the documents reveal that the suit properties were purchased before her marriage to her deceased husband. Full stop. Before her marriage to M.T. Kikong. Full stop. The petitioner is the adoptive son of late M.T. Kikong, who adopted the petitioner when he was 2 years old.
Yes.
When he was 2 years of age, full stop. The petitioner's
Birth father.
from the
Petitioner's birth father is the adoptive father's brother.
elder brother,
Yes.
and the petitioner's birth father is the elder brother,
Adoptive father's younger brother.
or a younger brother of Mr. of late Mr.
M. Kikon.
M.T. Kikon, late Mr. M.T. Kikon. So several allegations were brought up against the petitioner, which, according to the submission of the learned counsel for the petitioner, is to be taken with a pinch of salt. Full stop. It is further submitted that from the plaint itself, it is evident that the plaintiff has left her respondent. The respondent has left her matrimonial home on 23/10/2023 and full stop. And full stop. It is pertinent to mention at this juncture that it is pertinent to mention this juncture. The learned counsel for the respondent has submitted that it is pertinent to mention at this juncture that since 23/10/2023, the plaintiff Nalaya, respondent has not returned to her matrimonial home. Full stop. So that decision was in her favor. Suit was
Yes,
agreed.
yes, yes. In spite of the trial court order.
As at present, the petitioner is residing in the suit premises described in the plaint of TS number 2 of 2024. Full stop. As the suit was decreed, as the suit was decreed in favor of the.
Not decreed, Your Ladyship. An interim injunction was granted during it.
Okay. As during the pendency of the suit, interim injunction was granted in favor of the respondent. What was the interim injunction order?
That the petitioner is restrained from entering into the suit process.
Okay. Restraining the petitioner from entering into the suit premises, the petitioner who is at present residing in the suit premises is apprehending that he may be thrown out from his residence. He may be thrown out to the streets from his residence. Full stop. It is submitted that it is a fundamental right to have a roof over one's head. Okay. Because you're filing a writ petition to
I filed under 227.
Okay.
227.
Oh, under 227.
Yes.
Okay. Fundamental right to Nalage. Fundamental. The petitioner will be without a roof over his shoulder. Full stop. Oh, roof over his head. The petitioner has his residence within the suit premises only, and he has nowhere else to go.
Yes, Your Ladyship. My wife and son live there.
His family members, including his wife and son, are also residing in the suit premises. Minor son?
Not anymore.
Not minor. The petitioner has thus prayed to stay the operation of the After considering the submissions at the bar, it appears that the order restraining the petitioner from entering into his house the order to the order, so far concerning concerning restraining the petitioner to, I'll tweak the order later.
Very well, Your Ladyship.
The petitioner from entering into his present residence may be stayed, at least till the next date of listing. Meanwhile, issue notices to the respondents returnable within 4 weeks.
Very well, Your Ladyship.
We'll need the scan copies of the, not required, maybe.
necessary.
I don't think so.
Notice
You have
by-
annexed everything.
Yes, everything. Notice by speed.
Within, yes.
Notice by speed.
Notices by speed post returnable within 4 weeks.
Very well.
Speed post or speed post, okay.
Very well, Your Ladyship.
I won't mention you take notices according to your convenience. Dusty or speed post?
Just the petitioner takes steps.
Petitioner, speed post, Um, I mean, meanwhile, the order restraining the petitioner from entering into his present residence is stayed till the next date of listing.
Much better.
So there will be a tweaking and tinkering of the order because
Very-
I have myself forgotten what I have.
That's all right.
Dated.
Quite understandable.
Yeah.
Please, Your Ladyship.
Yes,
Your
yes.
Ladyship, I seek Your Ladyship indulgence in item 1 and 2.
Ah.
I've gone through the IA and it appears that the IA is for suspension of the conviction. Your Ladyship here, if the interim is run at this stage, it will amount to the full relief.
No, I
So
won't,
my-
I won't
my-
interim, only bail.
Yes,
I
my
won't done
humble prayer.
interim.
Your
We'll
Ladyship,
not
then,
dispose of that.
then Your Ladyship, let notice be issued and the TCR be called.
But I must hear the other side, no?
Yes, yes, the petitioner counsel is here.
You are here?
Yes.
Okay.
Yes, you
So
will.
1 and 2.
Yes.
Because he's already on bail.
Yes, yes.
So I'll only
So-
grant bail. I won't pass any suspension order.
When the petitioner is already on the bail, then
Say,
If-
okay,
if-
okay. If suspension
Yes,
sentence,
yes.
okay.
just for the suspension of conviction.
Then.
Yes.
No, suspension of sentence, Your Lordship.
Hmm.
Your Lordship, not suspension of conviction.
Hmm.
And the BNSS is very specific on that.
Hmm.
Section 401, suspension of sentence and grant of bail during the pendency of the appeal.
When the petitioner is already on bail,
And four,
the purpose of
403,
suspension.
same thing, same provision. That is by the trial court which convicts.
Your Ladyship, in the interest of justice, let notice be issued and the matter can be heard at the earliest.
I don't know, earlier in, see, I'm not very familiar with the BNS. But earlier, when we were dealing with this CRPC, it is, if it is 3 years and less than 3 years, we have to grant bail.
Yes.
Ladyship.
But now I don't know, let's see.
Bail, yes.
Same provision. It's just the
Enjoying the
numbers have
bail.
changed. Your Lordship will come to section 430, BNSS. We can go through the section. Section 430 of the BNSS.
So even if a person is sentenced, this cut off this video conferencing.
Section 430 is that.
Even if a person is sentenced, if we do not suspend the sentence, can't we grant him bail?
No,
the-
Your Lordship.
They are enjoying the bail right now. Yes.
We can extend.
By virtue of the lower court's order, they are enjoying the bail.
We'll extend the previous bail.
No, that they can approach the appropriate forum.
No, that's not correct, Your Lordship. Kindly come to section 430.
Ladyship, yes, yes.
Section 401, no?
430.
430.
Which is now 430, Your Lordship. It's at page 432, Your Lordship. We are having the same book, I think, at page 432.
Same book,
Yes,
page 432.
yes,
I'll go straight to 432 then.
Page 432.
Page 432.
yes. 432.
No, no, no.
Then.
I'll have to go to BNSS.
Yes,
No,
BNSS.
no, no.
Yes, BNSS.
BNSS, Your Lordship.
I'll have to go to BNSS.
Yes. Section 430 then, Your Lordship.
Section 430.
430.
This book is so confusing.
Lordship, this matter is fixed for admission hearing. It's for.
Please, Your Lordship.
Mm.
Lordship, I may be allowed to make a mention on behalf of Yang Wari, who is representing for the respondent number 1 to 4, Your Lordship. Only today we have received a copy from the state, so if 2 weeks' time will be given to me, Your Lordship.
Okay.
For
Yes.
admission hearing, Your Lordship.
Lord. If it
He has
can
received
be
copy
fixed on
only
the
today.
15th
Your Lordship.
15th,
15 April.
15 April.
Your Lordship.
Learned Counsel, Mr. Moa Jamir is present for the petitioner. Learned Counsel, Mr. Yonim,
Xinjiang Pong, Your Lordship.
has prayed for, on behalf of
Yang Wari CGC, Your Lordship.
CGC,
Yes.
on behalf of Learned CG, Mr.
Yang Wari, Your Lordship.
He will know, no? She will know his
Your
name
Lordship.
better.
Your Lordship.
And you are for
My Lord, I'm appearing for respondent number 5, 6, and 7. State respondent 5, 6, and 7.
Government Advocate,
Yes, ma'am.
Learned Government Advocate, Mr.
E.T. Papom.
Huh?
E.T. Papom.
E.G. Papom is present for the for the state respondent. Full stop. Adjournment has been sought on behalf of Learned CGC as they have received a copy of the petition today.
Yes.
Objection or petition?
By the state.
Copy of the
Affidavit in
affidavit filed by the affidavit in opposition filed by the state today.
Your Lord.
List this matter on 16. What did he say? 15th.
15 4.
Your Lordship.
Necessary orders even in item number 12.
Hmm?
Similar
Similar
order.
order.
Similar
Yes,
order.
Your
nine.
Similar order
Yes.
in item number 12.
Obliged. Your Lord.
Hmm.
Obliged, Lordship.
For admission, item number 16.
Oh, that are. This is the only one left. Or anything else? 2 more matters left.
May I please?
Can you conclude before this half?
Yes, we have 20 minutes time.
Mm.
I'll try to finish before that.
Because you cannot spill over tomorrow. Tomorrow we-
I know
we-
that, Lordship. Virtually, my submission have been concluded on the facts and the other points, but
Okay, got it.
I was.
Yes, only you were about to submit something else, no?
Yes.
Judgment
In
day.
the two judgments which my learned friend has referred to.
Yes, you wanted to counter those judgments.
Yes. So only on the judgments, Lordship. First case which my learned friend has referred to is 2019 1 JLR 196. 2019 in JLT it is 1 JLT 409. In this judgment, the contention of the
2019, 1 year,
2019 1 JLT 409.
409. You want to counter?
Yes. Here, the contention of the petitioner Lordship will find at page paragraph 2. That is the short facts where the writ petitions on what ground the writ petition has been filed. That is mentioned in paragraph 2. It's a short paragraph. He was punished, excommunicated from the village for 11 years with other restrictions and imposed fine also. And his supporters were also fined. That is the contention
Yes.
of the petitioner. To counter that, in paragraph 10, the respondents has raised 2 points. Basically, contention of the respondent is in paragraph 10. There, basically 2 points have been raised. One is no writ lies against a private entity. That means against the respondent number 4 and 5, that is Putuminde and Sunsumongtam. So, no writ lies. That was the objection raised.
You're drawing my attention to paragraph 2 and paragraph 10
Yes, that is
of your objection
of the judgment,
of the judgment. Okay.
of the judgment.
Okay.
Because what were the issues, what were the contention of the parties, that is very important, whether it will be relevant in our case or not. So paragraph 2 is the contention of the petitioner. In paragraph 10, the respondent has raised the objection with regard to the maintainability of the writ petition on 2 grounds. That one is no writ against the private entity. Number 2 is respondent number 4 and 5 are not state within the meaning of Article 12 of the Constitution. Here, on put objection to the contention of the writ petitioner, I have absolutely no argument on this. Unlike those cases, Votumandan is a village council. It is a state within the meaning of Article 12. So I'm not opposing, rather I'm conceding, yes, it is a state within the meaning of Article 12 of the Constitution. And it is not a private entity, as has been claimed in that case. In this particular case, I'm saying yes, village council is a state within the meaning of Article 12 of the Constitution of India. Secondly, respondent number 4 and 5 in that case is a state within the meaning, and it is not a private entity, it is a state. And
Yes.
Lordship will find the findings on these 2 issues. The finding is in paragraph 87 and paragraph 88. And the summary of the finding of the Honorable Court is, when there is a dispute between fundamental rights and customary practices, when there is inconsistencies, fundamental rights will prevail over the customary practices, customary law. That is what my learned friend has also submitted yesterday, and I fully agree on that point. If there is conflict between the fundamental rights and the customary law, definitely the fundamental rights will prevail over the customary law.
This judgment you were referring to which paragraphs? Mangyang Lima?
Paragraph 10 and 23 to 24. Paragraphs 10, 23 to 37, that is with regard to the.
23 to 37.
Yes, and then 85 to 90, which the nearest senior council is.
I'm
referring.
coming to that.
Yes.
And I'm referring to paragraph 87 and 88. In paragraph 87, this Honorable Court came to the finding that fundamental rights over the customary right, when there is a conflict. That also I agree. Why I agree, I will come in a later stage. And in paragraph 88, the finding was the village council do not have the power to punish or excommunicate a person. So that is the summary of the finding in paragraph 88.
Just one question.
Lordship.
See, he was not excommunicated. He was not excommunicated.
Yes, that is why it is not relevant. That is why I'm trying to come on that conclusion. And another finding in paragraph 88 is the village council, the order passed by the village council, that is the Butuminder, is violative of Article 19, Clause 1, more particularly sub-clause T and E, because he was debarred to come to the village by the village council. In that case, in Mayang Lima's case. So, total restriction on all fundamental rights. But what is our case? whether there is punishment, whether there is excommunication, both, no. No punishment,
No
no
excommunication.
excommunication. Had we
Only,
restricted,
no punishment, no excommunication, but only
Yes.
no non-cooperation.
yeah,
Non-cooperation, and
No.
then there is a state which is saying, which is giving license to its citizens to do whatever they want against me.
Mm.
That it has its
Okay.
implications. That is the position, and it is a. I'm also stating that it violates Article 19(1), 19(a), which is freedom of speech and expression. It's a fundamental right. All this, and then the right to life. All this. In the other case, it may have been with regard to residence and all those things, but here, in my case, it is also a violation of the fundamental rights. As simple as that.
yes. And the other point which was raised was there is violation of principles of natural justice. That is another point. And the fourth point is there is no social boycott in this case. Whereas in Mayang Lima's case, there was social boycott. It is just a reverse in our case. What happened in our case? We are asking him to move freely and to come to our village. Mayang Lima's case, he was part to come to the village. But rather, we are inviting him to the village. He is not willing to come. So, where is the violation of freedom of movement? Where is the violation of freedom to reside? Absolutely not. Nothing of that sort. And we have no social boycott. And there is no conflict between the fundamental rights and the customary law in this particular case. Unlike that of Mayang Lima's case. Coming to the second case, therefore, Lordship, this Mayang Lima reliance met in Mayang Lima's case is not relevant and not applicable in this present case. The next case is Chalukhamba case. That is from respondent number 4 village. It happened during election. The by-election is going on in the same constituency. It is WPC number 128 of 2023.
Okay.
Judgment and order is dated 21/3/2024. In this case, the fact
128 of 23, no?
yes. In this case, the facts is in paragraph 2.
Please give me this. You have
It
given
is there.
WPC 128.
Yes.
This is that act. This is okay. Yes, thank you. Paragraph
Facts
2.
is in paragraph 2. The point which was raised by the petitioner. And here also the same objection was raised with regard to the jurisdiction. In paragraph 14. The issue of jurisdiction has been dealt with in paragraph 14. But unlike those cases, we are not raising the jurisdiction as I have submitted earlier. And the finding of this Honorable Court is at paragraphs 16 and 17. And the conclusion was arrived that since the petitioner has been debarred for being a part of the Chungtia village, and then he was excommunicated from the citizenship of Chungtia village for lifetime by respondent number 4. Therefore, how can you pass this kind of an order? It is absolutely violation of fundamental rights, including Article 21 of the Constitution. And in fact, that is not reasonable. I rather support that ruling. But in our case, we are inviting him to the village. He is reluctant to come. So where is the violation of fundamental rights? And freedom of movement under Article 19, Clause 1, Subclause D and E is also not violated in these two cases. I have only 5 minutes left, so I will cite two judgments and thereafter I'll conclude, Lordship. First, the separation of material facts and approaching the court without clean hands. I'm referring 2010 to SCC, page 114, paragraph 7. Only one paragraph, Lordship. 2010 to SCC 114, paragraph 7. This is on the point of separation of material facts and approaching the court without clean hands. I may be allowed to read this paragraph. It's a short paragraph.
Paragraph 10?
Paragraph 7.
Okay.
It's a recitation of earlier judgments. If Lordship permits me,
Yes, please read.
I may be allowed to read this. Paragraph 7. May I read, Lordship?
Yes.
In Prestige Light Limited versus SBI, it was held that in exercising power under Article 226 of the Constitution of India, the High Court is not just a court of law, but is also a court of equity, and a person who invokes the High Court jurisdiction under Article 226 of the Constitution is duty-bound to place all the facts before the court without any reservation. If there is suppression of material facts or twisted facts have been placed before the High Court, then it will be fully justified in refusing to entertain a petition filed under Article 226 of the Constitution of India. This court referred to the judgment of so-and-so in the next para. In exercising jurisdiction under Article 226 of the Constitution, the High Court will always keep in mind and conduct of the party who is invoking such jurisdiction. If the applicant does not disclose full facts or suppressed relevant materials or is otherwise guilty of misleading the court, then the court may dismiss the action without adjudicating the matter on merits. The role has been evolved in large public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. The very basis of the jurisdiction rests in disclosure of the true, complete, and correct facts. If the material facts are not candidly stated or are suppressed or are distorted, the very functioning of the writ courts would become impossible.
Okay.
Other background I have already narrated, so I have already made submission on the earlier occasion, so I am not reciting that. The next, and this will be the last, this is with regard to the applicability of the custom. In what degree and in what manner the custom can be applied. 1996, 5 SCC 125, paragraph 5. I will refer to only this paragraph and I will conclude my submission, Lordship.
Okay.
May I read, Lordship? In the facts of these divisions and visible barricades put up by the sensitive tribal people, valuing their own custom, traditions, and usages, judicially enforcing on them the principles of personal law applicable to others on an elitist approach or an equality principle by judicial activism is a difficult and mind-blowing effort. Brother K. Ramaswamy J. seems to have taken the view that Indian legislatures and the governments too ought not prompt themselves to activate in this direction because of political reasons, and in this situation, an activist court apolitical as it avowedly is, could get into action and legislate properly on the lines as suggested by the petitioners in their written submissions. However laudable, desirable, and attractive the result may seem, it has happily been viewed by our learned brother that an activist court is not fully equipped to cope with the details and intricacies of the legislative subject and can at best advise and focus attention on the state polity, on the problem, and shake it from its slumber. Courting to it to awaken, march, and reach the court. For in whatever measure be the concern of the court, it convulsively needs to apply somewhere and at some time, breaks to its self-motion described in judicial parlance as self-restraint. We agree therefore, Brother K. Ramaswamiji, as summed up by him in the paragraph ending on page so-and-so of this judgment, that under the circumstances, it is not desirable to declare the custom of tribal inhabitants as offending Article 14, 15, and 21 of the Constitution, and each case must be examined when full facts are placed before the court. So here, what custom has been violated? My learned friend was focusing heavily on the jurisdiction of the village council. We are not disputing that. Yes, village council has the jurisdiction to administer justice within the village. But the Village Council Act has never taken away the customary practices of the owner. Section 3, Section 4, Section 6 proviso, Section 14, all the sections Lordship will find has allowed custom to be used. And our custom is when a person does something outside the jurisdiction of the village, we summon him to the village and settle the matter. That is our custom. Therefore, the jurisdiction of the village council within the village will have no reliability and relevance because of the fact that this is something which has occurred outside the village jurisdiction. So in such a situation, village council cannot go there to the accused where he resides, but it will summon and settle the matter in whatever manner it is required to be settled. That is our custom. And who can say that, no, this is not your custom? And the provision is silent. The Village Council Act is silent about the incident that has occurred outside the village. Therefore, we have applied our custom. And what is wrong by applying our custom? Therefore, all the ingredients which are required to be satisfied by approaching the Honorable Court, in the first place, petitioner has no locus standi to approach the Honorable Court because there is no violation of any fundamental rights. And whatever order was passed by the respondent number 4, that has been passed in accordance with our customary practices and usages. With that, Lordship, I would like to conclude.
Just one question.
Lordship.
You see, every statutory body, suppose a district court,
Yes.
high court, everybody has a standing counsel to
Yes.
represent it
Yes.
for mediation or for anything. You don't have to go, but the standing council will represent.
Lord.
Is there anybody to represent a village council? Just for mediation purposes, I'm asking.
No.
No.
Lordship.
Okay. All right.
Calling him to village is a process of mediation only. We call him to
Yes.
settle.
I understand.
He is reluctant to come. I don't know why he is so scared to
I understand.
visit
It is more of
own
a
native
mediation
village.
court. I understand.
And the two rulings are totally opposite. In that two cases, petitioners were restrained to come to the village. In just the reverse, we are calling him to come to the village. He is reluctant to come. Why? We fail to understand. And he pleaded for more time to enable, so as to settle the matter. And hurriedly, he approached the Honorable Court. and obtain a stay without hearing the other side.
Okay, we'll conclude it then.
Other respondents are there, that may be after a break.
Okay.
But I believe they will not take much time. I don't know how long. they
You
will
want to
take.
place the submissions?
Yes, please.
Okay, after the break then.
Yes.
Okay. We'll leave it like this.
Yes, ma'am.
One more book is, yesterday I have recorded the arguments in one book. Then today I have recorded in another book. I'll arrange it later. No, into one book, full book, this one. I'll arrange it later.
If it is misplaced, then all my argument will go.
I'll forget everything. I know.
Much obliged. Lord, my submission is
Yes.
already over.
Yes, yes.
I have a prayer
Mm.
that some of our colleagues from Gauhati has come.
Yeah.
They want to have some discussion, official discussion in connection with the Park Council election.
Okay,
So my appearance may be dispensed with, Lord,
okay.
because I have already concluded my submission.
Yes, yes, sure. Reserve. Step. In P.
Stapler.
There'll be one more. Yes,
Lordship, please, your Lordship.
yes,
In fact, Lordship, I'm a substitute candidate of the Government Council here.
yeah.
Actually, it is handled by my learned colleague LD Sandam, AAG. Since because of his personal problem, I was compelled to address your Lordship today.
Okay, okay.
And considering the facts and matter of the case, our government has a very limited power to rule
Okay.
in the present case. But your Lordship here, we have a law.
On behalf of LD Sangam, you are submitting?
Yes, yes.
Okay, so whose name I'll record for today?
Since
I'll record your name.
Okay, I am
Please,
Song.
your name, please, once.
I am Song.
I am so.
Double H.
এই যে নামটো লিখি থৈ দিবা হা on behalf of LD Samtang no
Sanctum.
Santam I am song on behalf of LD Samtang লিখি থৈ দিবা
Petitioner 80 order.
yes yes yes
Lordship here, in order to administrate and to deliver administration of criminal justice and civil justice for the villages, we have one law, Village Council Act, 1978. And that act is stemmed up from the
I think he has given a copy of the
yes, 1978.
Council Act.
Yes. So that act is recently on 2022, fifth amendment was made 2022. So as per the latest amendment, that is the Village Council and the Council Act 1978 Amendment 2022, Rule 14(1).
Yes, yes, amended, yes.
Yes.
He has submitted, I think.
Is it submitted?
Already submitted.
Yeah, and that particular rule is, if it is already submitted by my learned colleagues earlier,
Yes, he has
don't
submitted.
waste my time to.
He has submitted that deleted article, which was again incorporated
Yes, yes.
by amendment
Yes.
in 2022.
Yes, yes.
Okay, yes,
If
yes.
it is already submitted by my learned colleagues, then in that case, I don't need to waste time also.
This will be section 14 or rule 14?
Section
Section
14(1). 14(1).
Yes.
And that I just want to elaborate on that. Section 14(1), that as per the 2022 amendment, it is stemmed up from the rules for administration
Yes.
1937, Rule 24.
Yes,
So
yes.
we have to link with that.
Yes, yes.
So if it is already mentioned, then my submission was
Yes, yes, he has
Okay.
elaborately submitted.
okay. Then I will be relieved.
Yes,
Because
yes.
then I have
Sure.
nothing much to roll here.
Lordship, I'm representing respondent number 5. Respondent number, the history of respondent number 5 has already been explained
Yes, yes.
by the letter senior counsel
Yes.
representing respondent number 4. But in order to substantiate the standing, if I may be allowed to just refer to one or two facts, because that will be very important for determining this case. Now, before coming, I'll be relying only on two documents, refer to 2 documents in the writ petition. But before going to the documents, Lordship,
Yes.
2 dates, 2 important dates, Lordship. It was in the year 1960. It was in the year 1960, more particularly on 27th of December. 27th December 1960, that it is very important. Now, it was on this particular day, the citizens of this village, respondent number 4's village, that is Chungtia village.
Yes.
The citizens of Chungtia village and the village council of Chungtia village, that is respondent number 4. They took a decision. They took a decision, executed an agreement on 27th of December 1960. And the agreement was to form and establish a village. And that village is the respondent number 5's village.
Yes, I know.
Yes.
Your village.
Yes. Now the second date is, it was on 16th of January 1961, the village was established. 16 January 1961. Why I'm referring to this date? Counting from 16 January 1961, the village has
after the agreement, this respondent number 5 village was formed.
Yes. Now we have completed 65 years of our existence on 16 January 2026. 65 years. And this year is very important, 65 years.
Yes.
Now for the last 65 years, it is a usage and customary practice of these two villages, because the Linesini Council have already stated that the respondent number 5 is an offshoot of respondent number 4.
Yes.
Now, whenever any issues arising that touches the question of usage and customary practice, we go to respondent number 4 for advice. And it is not only in this particular case, for the last 65 years, that was the practice. For the last 65 years. This is not the first occasion. Whenever there are issues and when we think that there is a requirement for any advice, we seek the advice from respondent number 4.
Okay.
Now that is the brief background of the case. Now, Lordship, on perusal of the read petition, there are altogether 12 prayers in the read petition. Out of the 12 prayers, there are only 3 prayers against the respondent number 5. The first prayer is in prayer number 5, prayer number 6, and prayer number 11. 5, 6, and 11. Now, prayer number 5 refers to a document at page number 52 of the read petition. The typed copy, Lordship, will find at page number 53. So that is a document dated 12th August 2025.
Prayer number 5.
Prayer number 5, Lordship. And I'm sorry.
That is the news article.
No. It is just a letter written to the petitioner.
Oh, yes.
Summoning,
Yes,
yes.
come on. Page 53, yeah?
Page 52.
Page
The original document is on page 52. This is dated 12th August 2025. 12th August 2025. The content of this letter, Lordship, I'm sorry to trouble your Lordship,
Yeah, no
the
problem.
content of this letter, if I may be allowed to read it, it will take just a couple of minutes. May I read it, Lordship?
Yeah, please read it.
Because the content of this letter is very important insofar as respondent number 5 is concerned. Dated 12th August 2025 to Mr. May I read, Lordship?
Yeah, please read it.
To Mr. So-and-so, that is the petitioner. At the outset, we bring greetings in the name of the village council, the Chungtia Yimsun village. Write this needed letter because you failed to appear before the Chungtia village. That is respondent number 4. The intention is that you failed to appear before respondent number 4. We are compelled to read this letter. The Chungtia Yimsun village council, on being summoned by the Chungtia village council, have gone and had a joint meeting with the Chungtia village council to discuss the matter related to the said meeting. You are informed to appear before the Chungtia Yimsun village council on 19th of August 2025. It was just an information to come and appear before our council, not before respondent number 4, before respondent number 5.
Yes.
That is very important, the content.
Yes.
Now, Lordship knows about this now by now,
Yes,
section
yes.
14. We have the jurisdiction to summon him.
Yes, yeah.
The rules of 1937 clearly says the village council, the village court has a jurisdiction to summon my own citizen, or for that matter, any other citizen. Now coming to respondent number
The Act of 1978.
Act of 1978 and the rules of 1957. For the applicable, I have the jurisdiction.
Rules of?
1937, Rules for Administration of Justice and Police in Nagaland.
Oh, yes, yes,
1937.
yes.
Yes, the rules which we have.
And rule 30?
Rules of 1937.
Yes, yes.
Lordship has
Yes,
already
yes,
asked
yes.
copy of these rules. And section 14,
Mm.
Lordship is well aware of 14 now. Now that is the letter. The second, which they have impugned, the second is page number 55.
You have filed an objection?
I have filed my objection.
Oh.
I have,
It
in
is
fact-
mentioned there?
Yes, I have.
It's
In
mentioned-
fact, I have raised preliminary objection.
Okay,
Preliminary objection on the maintainability of the read petition.
okay.
Now I'll come to that because we are in the hearing stage. Now I'll also refer to that. Why I have raised a preliminary objection. Now the second document which they have challenged is dated 20 August 2025. The first is 12 August 12/08/2025 and the second is 28/2025. May I read it, Lordship?
Yes.
Page number 55, the last page of this read petition. At the outset, we convey our love. So and so, right, a needful. Thus, we, as you informed us that you would be out of station on 19 August, because he was first summoned on 19 August, he has expressed his difficulty saying that he will be out of station, which is why we were compelled to issue the summons again. And now the second scheduled date was on 28th of August 2025 to appear. Nothing more, nothing less. Just to appear before us. That was it. Now, Lordship, the objection which I have raised, because they have pleaded respondent number 5 of us, one of the respondents, they have also challenged this to document. The third prayer Roman 11. Roman 11 is to refrain us from summoning him, further summoning him. That is the third prayer. Because the first two letters that they have challenged, we have summoned him. The third prayer in prayer number 11, Roman 11 is to refrain us from summoning him.
Okay.
Now, Lordship, by summoning an individual, what fundamental right has been infringed? That is the preliminary objection that I have raised. So it is really clear that it is clear from the document that by summoning someone, no adverse action has been taken, no decision has been taken, no order has been passed against the petitioner. On what basis? In other words, no adverse action has been taken against the petitioner. So this is a misconceived read petition. It is unsustainable in the eye of law. And so far as respondent number 5 is concerned.
Okay.
Now, in order to substantiate on the two citations, the judicial pronouncements which the learned petitioner's counsel has relied upon, of all the other citations, there are two which were decided by this honorable court and which the learned senior counsel for respondent number 5 has also relied upon.
Yes.
These two citations, the Mayanimas case and
Yes,
the
yes.
Salokumpas case, WPC 128 of 23. With due respect, my respectful submission before this honorable court is, it is irrelevant in the facts as well as in law. Both the citations are irrelevant in facts as well as in law. The relevant paragraphs has been already played before this honorable court.
Yes, yes. Has been read.
Yes. In these two cases, it is mainly to do with a violation of fundamental rights. It was
Okay.
pertaining to election. They were refrained from contesting or they were refrained from entering in their own villages. Yes, I fairly admit that that was a clear case of violation of fundamental rights. Now coming to my case, by summoning someone there's no violation. There's no violation at all.
Yes.
In fact, I have jurisdiction to summon him as many times as I wish, so far as there is a reasonable ground.
Okay.
Now, even assuming that he is aggrieved by the summoning letter, now coming to Rule 31 of the Rules of 1937, Rule 31 clearly provides appellate jurisdiction. Rule 31 is an appeal to Deputy Commissioner or his assistant against any order passed by local authorities. I'm also a local authority, I'm a local court, a village court. There is a clear provision. Now the law says, the law is very clear, when you have an alternate remedy, you have to exhaust that remedy. Without exhausting such remedy, the petitioner is before this court challenging the two summoning order as far as respondent 5 is concerned. So the writ petition is misconceived, unsustainable, it's liable to be quashed set aside. If I may be allowed to rely on one judgment of the Honorable Apex Court.
On which ground?
Alternate remedy.
Okay.
Alternate remedy. Paragraph number 36, 37, and 47. 36, 37, and 47.
Leelavati and others.
Yes, Lord. This civil appeal of 2025. This is a judgment dated 16 October 2025, Division Bench of the Honorable Supreme Court. Lord, you will find this relevant paragraphs at page number 28. Page number 28.
16 August 25.
Yes, Lord. 16 October, 16/10/2025.
16/10/25.
Yes.
What are the relevant paragraphs?
Relevant paragraphs 36, 37, and 47.
Okay.
36, 37, and 47.
Okay.
Short paragraphs, if I may be allowed to take
Yes,
it on.
yes.
Page 28. The Lord, may kindly take the trouble to turn to page
Page
28.
28, yes.
May I read, Lord?
Yes.
36. A careful perusal of the opposite judgments leads us to the conclusion that where an efficacious alternate remedy is available, the High Court should not entertain a writ petition under Article 226 of the Constitution of India in matters falling squarely within the domain of the tribunals. Now, for this case, if I may be allowed to rely on Rule 31 of the rules, there is a statutory provision. When there's a statutory provision, they should have access to the remedy instead of coming before this honorable court. 37. Nevertheless, a writ petition under 226 may still be maintainable, notwithstanding, this is very important, the existence of such an alternate remedy in exceptional circumstances. Now, the petitioner has to make out an exceptional circumstances why he is before this honorable court. Now, the circumstances, including enforcement of fundamental rights, the first and the foremost, enforcement of fundamental rights guaranteed under Part 3 of the Constitution. Second, instances of ultra-vires or illegal exercise of power by a statutory authority. Insofar as Respondent 5 is concerned, by summoning the petitioner, what violation has he done? What adverse order has it passed? What is the illegal exercise? Because I have the jurisdiction to exercise my power. Third, violation of the principles of natural justice. He was summoned. He failed to appear. Fourth, on where the virus of the parent legislation itself is under challenged. None of this, with due respect, none of this. So these are the exceptional circumstances. The petitioner has failed to make out a case that this particular case falls under the exceptional circumstances or any of the exceptional circumstances. Which is why the writ is not maintainable. Coming to paragraph 47, page 33. Thus, we are of the considered view that the division bench of the High Court has rightly set aside the judgment passed by a single judge and had not committed any illegality, partly allowing the appeals by the first set of so-and-so and relating the matter to so-and-so for adjudication. It was referred back for adjudication to the appropriate forum. The division bench of the High Court had rightly held that the writ petitions before the High Court are not maintainable on this ground. Therefore, my respectful submission before this Honorable Court is, insofar as respondent number 5 is concerned, no adverse order has been passed, no illegal action has been committed against the petitioner. Therefore, the writ petition is not maintainable insofar as respondent number 5 is concerned.
Okay.
May I please, Your Lordship?
Mm.
Lordship, I am declaring for respondent number 6. Here,
Your
respond
name?
Aliba Uzukum, Lordship.
Ali?
Aliba Uzukum.
Aliba?
Uzukum. Yes.
His name.
Lordship, here, respondent number 6 is arrayed as a party
Mm.
due to the press release
Mm.
made in the local dailies, which has a direct link with the petitioner's article, which is at Annexure B to the writ petition. Otherwise, my article is annexed as Annexure A and A1 and A2. So it is directly linked to that. Otherwise, critically, the petitioner has never challenged or have claimed any relief against the respondent number 6. So my presence in this present writ petition is only nominal in nature. Further, without prejudices, I would like to support the legal stance taken by respondent number 4, as well as respondent number 5, to the extent that the very dispute at hand concerns is deeply rooted to customary practices and usages in the state of Nagaland, more particularly Mokokchung, that is governed by Putu Menten. So therefore, the exercises so meted out by the respondent number 4 and 5, that is issuance of the summon by respondent number 4 and the direction conveyed by respondent number 5 are within the ambit of the Act of 1978 under the umbrella of Article 371A, which permits the usages of customaries and administrative practices in the state of Nagaland. So therefore, the claim so made by the petitioners that the respondent do not have the authority to initiate such action is wrong, is not correct, or it's not ultra vires the act. So I adopt and concur to the submission made by the respondents. Now, in my affidavit in opposition, I also taken stance on maintainability. The first ground is that they have not exhausted the alternative remedy by approaching the appellate jurisdiction. That is, they would have approached the TC as per the rules 1937 rules. Otherwise, they have directly rushed to the Constitutional Court by invoking the writ jurisdiction. That is my first ground for maintainability. And second, the petitioner has also failed to demonstrate
1937 rules or act?
rules.
No.
1937.
It will be Rule 31, no?
Yes, more specifically, Rule 31. That is the provision for appeal. My second ground for maintainability is that the petitioner has failed to establish the basic violation of fundamental rights. Otherwise, more particularly, Article 19(1) Clause G, that is freedom of speech and expression, is not absolute in itself, but there has to be a reasonable restriction. Meaning thereby, Lordship, here the article so meted out by the petitioner has inflicted the moral sentiments of a larger people of this residents of Mokokchung, and more particularly my village, that is respondent number 6 village. So therefore, the exercise taken by the petitioner itself is questionable, and that cannot amount to infringement of fundamental right. So that is my second ground for maintainability. Now, to support my submission, Lordship, I would like to refer to my affidavit in opposition, paragraph number 3,
6, 7, and 8.
Okay.
And also, I pray before this court that this court might held that my presence in the present case is only a nominal in nature, and the relief sought, and no relief has been sought against respondent number 6. That may be reflected.
Okay.
That is my respectful submission. Obliged.
I'll go to the submission of the learned senior counsel. He has filed 2 affidavits, Your Lordship. I'll take the 2 affidavits, I'll take your worships to it. First, the second one affidavit was filed after the order dated 23 of 2026 was passed by this honorable court regarding the jurisdiction. The learned senior counsel has harped on the fact that I have come with unclean hands. Now, what is the statements that is given in the affidavit? Whether he has made any such objection, raised any such objections or not is to be found in the affidavit itself. If it is not there, then it cannot be just because a counsel wants to submit at the bar something which is not there in the affidavit itself, that cannot be permitted.
Yes.
Your Lordship. So, Your Lordship, whether the learned senior counsel has made any statement about suppression of material facts. Your Lordship, if Your Lordship will go through the entire affidavit.
Affidavit dated 24/3.
Yes, here.
24/3, yeah.
Yes, if Your Lordship will go, there is a paragraph, and even the statements made here is contrary, it contradicts the order passed by this honorable court. Your Lordship will see paragraph 2. That the deponent, if I may read, Your Lordship, that the deponent begs to state that on 23/2026, while the present petition was taken up for hearing before this honorable court, the counsel for the petitioner had categorically made a submission that the petitioner neither belongs to the Chongdia village, respondent number 4, nor Chongdia Yimsen village, respondent number 5. Which is contrary to the statement made in paragraph 2 of the aforementioned writ petition, Your Lordship. Whereas if Your Lordship may go into the order, there is no such reflection. But he has, out of nowhere, pulled up this fact and raised this. Nothing is mentioned about suppression of material facts. So now, at this stage, just to bring in something out of nowhere and then make an issue out of it and say that there is suppression of material facts, it cannot be permitted. It cannot be allowed. The affidavit itself must mention specifically what is the suppression of material fact. No mention is made about suppression of material facts, even in this last affidavit or in the other one. And his case is that just because this honorable court has recorded that I have been staying out of in Dimapur for the last 2-3 decades.
That is the case.
That is the only.
That decades.
Yes, decades. He is conflating residence and citizenship. A person of Indian origin, he is an Indian citizen, he may stay in America. So long as he does not transfer his citizenship, he still remains a citizen of America. Similar to that, even in our community, I remained a citizen of a particular village until I shift. I shifted my city. I was staying in Dimapur, but I decided to shift my citizenship from the respondent number 4 to respondent number 5. That is why in 2019, I applied. They also allowed. I became a citizen of respondent number 4. That's 5. That does not mean that I am still a resident of respondent number 5. I am still resident at Dimapur. Residency and citizenship are 2 different things. The learned senior counsel has conflated everything as though me seeking transfer from the respondent number 4 village to respondent number 5 village shows that I have been resident in that village. No. Domicile and citizenship are two different things, even under the constitution. I'm resident at Timapur for the past so many years. So there is no separation of material fact. Also, the learned senior counsel has not met in his affidavit, there is no statement about separation of material facts. Therefore, that point which he has submitted before his honorable court should be thrown out outright. That is one aspect. Now, the learned senior counsel has sought to, it's very unfortunate, has sought to project that Naga customary law, our Naga customary laws are very primitive. The way he has stated it appears to be that it has no connection with the modern laws. No. It was never like that. Our laws are, customary laws are, have been there since ancient times. Our villages, I happen to be the citizen of a village which is deemed to be the village from which all the other villages of
No, but this is not required actually.
they are not
Responsibility is,
yes.
he was
But-
narrating the history
Yes.
of the formation and why
Yes,
Christianity
but
was
I
brought in.
wanted-
That
yes,
is the
I
reason
wanted
he
to
was
project that
saying all-
customary, yes. I only want to project that customary law, our Naga customary laws are very much in conformity with the constitutional provisions only. It is nowadays that the
No,
villages.
that
the-
not,
yes,
that
the
subject is not
villages are-
required altogether.
Yes, the villages are presently trying to allocate to itself powers which is not there in the statute. The statutory powers, they are governed by the statutory powers. If they go against the statutory powers, they cannot say that we have customary powers. No. All the powers are granted under the statute. They have to go by the statute only. They cannot go beyond that. Here presently they are saying the learned senior counsel was trying to project that, yes, I don't have any jurisdiction, but customarily I have jurisdiction. What kind of submission is that? Now, your lordship, the judgment which the council for respondent number 5.
Alternative remedy.
Yes, about that remedy, it is, he has tried to project that. In fact, it helps my case. This is why I want to take your lordship to the paragraph 37, which he was.
Reading.
Yes. Nevertheless, a writ petition under Article 226 may still be maintainable, notwithstanding the existence of such an alternative remedy in exceptional circumstances, including the enforcement of fundamental rights guaranteed under Part 3 of the Constitution, and this is very important, instances of ultra-virus or illegal exercise of power by a statutory authority. I am saying that this is ultra-virus action and illegal exercise of power by the village councils. Illegal exercise of power by statutory body. Village council is a statutory body. It cannot exercise powers which are not granted under the statute. Here, there is clear violation of the statutory provisions. So, the judgment which has, I
So
wanted
you
to
did not
emphasize-
appeal and you.
Yes, I have every right to approach this honorable court by way of this petition, and the judgment itself is very clear.
Yes.
That is my only submission. With that, I end my submission. Obliged.
I'm really very grateful that the submission has finally ended. I don't need to continue. You cannot pin it up here. It has become very thick on the last page. It has become so thick, we'll have to pin it up on the last page along with the wakalatnama. Below the wakalatnama. Why it is an extra copy everywhere extra like this for wakalat namas? Huh? Oh, not extra copy. It's okay. Below this wakalat nama. লিখি দিবা হাৰ্ড নামবোৰ লৈ লৈছা না অ'কে ৰিজাৰ্ভ ফৰ জাজমেণ্ট এণ্ড অৰ্ডাৰ
Respond number 4, senior city justice assisted by.
Rohit Secretary.
Yes, assisted by, the learned senior counsel is assisted by.
তেওঁৰ নামটো লিখি
Yes, the name.
তেওঁৰ
The name reflected.
তেওঁৰ নামটো লিখি দিবা দেই this act rules
Yes.
1978 act that is act the act I had
Then the
act I had because he has given me a copy
And
the
then
rules I have
rules for it, yes, only these two.
because there are sometimes in Gauhati library we cannot find this the northeastern the Arunachal Pradesh's local rules then we
Yes.
cannot find sometimes we can find but sometimes we cannot find in the library
You're right.
so it's very difficult so I'm taking
You're right.
here the list also somebody has given the list also
Your lordship, the next matter is also mine.
but no point no
Yes, there is an interim order, it may
I
be.
won't be
Yes.
able to absorb or I won't be able to
Your lordship, yes.
pass any order also. Tomorrow I'm leaving.
Your lordship.
And tomorrow I have only
No need
DB.
to pass any orders because the reply has not yet come.
Okay.
So only just to extend the interim.
Which one? Item
31. Item 31.
31. Learned Counsel Mr. T. Ponganar is present.
Yes.
Full stop. This is for orders.
Yes.
The other side is
Oh,
not.
we have also filed regarding.
It
Yes.
was mentioned in the morning.
Oh, okay, your lordship, then it's okay.
Nala Irukati mentioned question.
Then in that case, if it had been mentioned in my absence, there is an interim. If that interim may be extended, yes.
Please tell her to write the interim order.
It's a status quo order.
No, but who has taken down the dictation? Oh, Miru Kodibason, item number 31, interim order to extend Kodibara till the next date of listing, huh? Well, item number 31, WPC 26, 2026.
Yes, yes.
Order to extend Kodibara.
Your lordship.
For orders, item number 29.
Lordship, in this case, I'm representing respondent number 1. Lordship, while pending disposal of this petition, I have resigned from empanelment of the SBI.
Oh,
I have to withdraw from this case.
okay.
If all our names may kindly be deleted for respondent number 1.
You have withdrawn, but have SBI has have you informed the SBI?
Yes,
You
I've
have
already
informed.
communicated. They
Communicate.
will be engaging a new counsel.
Okay. Learned Counsel Miss.
Please, Your Lordship. Lordship, notice has been served to respondent number 2.
Okay.
However, till date, no one has represented respondent number 2. So, if this honorable court may allow us to issue notice through substitute service in one local daily newspaper in the state of Gujarat.
Your name? Item number?
29.
Malayo.
Yes.
Oh, last one is number. Learned Counsel Miss Malayo is present and has submitted that notices have been issued to respondent number 2 full stop. The Learned Council has also prayed to issue notice to substituted service to issue notice to substitute service by publication in a widely circulated local daily, full stop. The petitioner may take steps to issue notice through paper publication through a widely circulated local daily, i.e., which is mostly circulated here,
In the state of Gujarat,
In the
she's
state.
seeking for.
state of Gujarat.
Yes.
Okay, which is mostly widely circulated. In the local state of Gujarat, likhi diya. Widely circulated local daily in IE na lage, in the state of Gujarat. Learned Council, Mr. Muaz Amir is present and has submit for the respondents and has submitted that
Respondent number 1.
respondent number 1 and has submitted that he has already withdrawn his wakalatnama from respondent number 1 as he is not representing the SBI anymore as a standing counsel.
And penal counsel.
As a panel counsel, full stop. He has prayed for deletion of his name as
Along with all the associates.
deletion of his name and the names of his associates as counsel for respondent number 1, full stop. Office may delete the names of Muaz Amir and his associates as counsel for respondent number 1, SBI. Okay.
What do you mean? If we are allowed, what makes
It is also submitted that
Feature.
he has informed the SBI. He has also informed the SBI likhi diya. Kopot bhai diba. Yes.
instead of Moajame, P. Chanda and his associates, because he's the leading counsel.
P. Chanda and his associates.
Yes.
Muaz Amir na lage.
Mhm.
P. Chanda and his associates. Muaz Amir jagat P. Chanda likhi diya. Khali presence to यहाँ record koi diba.
Yes.
It is submitted on behalf of P. Chanda boli koi milai diba.
Much.
List this matter after 4 weeks. Paper publication. Gujarat 4 weeks.
For orders, item number 32.
Nobody is present, no? Nobody is present. Anybody present? And there's nothing in the office note also. Notice issued upon respondent to receive by registry's issuance. Service report is submitted. Parties, petition is not represented today. List this matter after 2 weeks. Over. No?
Hey. Who's it? Oh. Tick.